Verdict. We, the jury, finds as follows. The defendant is not guilty. So say we all, this 25th day of February, 2022, juror number 2, foreperson. In the courts of the 6th Judicial Circuit in and for Pasco County, Florida, State of Florida versus Curtis Jetson Reeves, case number 2014 CF 216 CF AXES, information 4, count 2, aggravated battery. Verdict. We, the jury, finds as follows. The defendant is not guilty. So say we all, this 25th day of February, 2022, juror number 2, foreperson.
Shocking moment for many folks, including myself. I mean, I was here on the air. We brought you that verdict on Friday here during closing arguments. Curtis Reeves set free by this jury. The jury listening to his self-defense arguments, listening to his testimony, believing it, and again, setting Curtis Reeves free. An absolute explosion of reaction on social media to this one. Let me just give you a little sample of what's out there and what people were saying. For instance, Lou T posting this. Why in the world is this verdict making me feel some kind of way? No justice for Chad. My heart is broken. Lisa, I can't believe Grumpy was found not guilty. Oh, wait, I can. He was old and, quote, feeble and an ex-cop. The jury just took pity on him. And then there was Cynthia, who I believe was more in the minority, but still a lot of folks posting out there. Yes, justice was served for Curtis Reeves. Maybe this will make people think to respect others and turn that darn phone off and put it away when in a movie theater. Yay for Curtis Reeves, good for him. The younger generation has no respect for the public. Wow, wow. Now, one of the reasons I am shocked because I covered the trial of the man on the left that you see right there. His name is Michael Drejka. He claimed self-defense in a very similar case in Pinellas County, Florida, which is right next to Pasco County, Florida, where Curtis Reeves was tried. Bunch of similarities. Let's start here with the first similarity between these two. Each one of these two started the verbal confrontation that began the situation that resulted in the shooting death. Let's start first with Curtis Reeves. He was in a movie theater. We've got the surveillance video of it and was questioning Chad Olson's use of a cell phone, starting that verbal confrontation between the two. Let's switch to Michael Drejka outside the convenience store at the gas station. There he is, again, in surveillance video, starting a verbal confrontation because someone is in a handicapped spot that doesn't have the handicap credentials. So both situations were started by the defendants. Now, let's take a look at the physical confrontation. And in both cases, the shooting victims start the physical confrontation. Let's first go to the popcorn toss. That is taking it from a verbal confrontation to a physical confrontation. And that was Chad Olson who did that. Okay, he started it, the shooting victim. Now let's go to Michael Drejka. The shooting victim in that case, Marquise McLaughlin, walks out of the convenience store, sees someone yelling at his girlfriend, the mother of his children, and shoves Michael Drejka. So in both cases, the physical confrontation is initiated by the shooting victim. Finally now, let's take a look one more time. Here we get to the actual shooting itself. And the shooting quickly follows the physical confrontation. We begin with Curtis Reeves, who once that popcorn is thrown at him, whips out that gun and shoots. And he says it's not a result of the popcorn, but was a result of the initial physical confrontation, which he claimed was the throwing of the cell phone. Okay? So Curtis Reeves says, I get hit by a cell phone, then some popcorn, and then I fire my weapon. Now let's take a look at what happens with Michael Drejka as he shoots and kills Marquise McLaughlin. Again, the physical confrontation starts from Marquise, and then he pulls out his weapon and fires and shoots and kills Marquise McLaughlin. Bunch of similarities, both shooting victims, fathers of young children, both shooting victims shot in front of their significant other who testified at both trials. Let's bring back in the think tank still with us. Bernardo Villalona, Michael Bixson, Al Wunsch III. Two cases, both self-defense, okay? Both self-defense, both in the same area of Florida with two completely different results. Michael Drejka behind bars for 20 years. Curtis Reeves this weekend walked his daughter down the aisle at her wedding. So, Michael Bixson, I'll begin with you. Make some sense of this to the folks at home. Why is one man serving 20 years and the other walking his daughter down the aisle?
Well, to be clear, I do think that there was a misapplication of the standard ground law in the Reeves case. So I need to lay that out there. I think it was the wrong decision. That being said, there was a distinct difference between the two cases in that in the Drejka case, the victim retreated. And so you had both the judge and the jury eventually shoot down the self-defense argument. Whereas when the Reeves case, you didn't have any issue of retreat. That being said, I still think it was a complete overuse of force. I do not think that standard ground should have applied in this case, and it was a completely wrong decision by the jury.
When you say this case? Which one? We've got two.
Reeves.
Okay, gotcha. Al Wunsch, explain to the folks at home why Michael Drejka is serving 20 years on the left of the screen and Curtis Reeves was at the wedding this weekend.
Vin, it's the end of the world as we know it. This doesn't make any sense at all. The situation with regards to Drejka, the victim was backing up, but the victim was backing up because he took a gun out. And so I think, most normal people would have been kind of backing up at that point. But he took a tumble. He took a fall. He wasn't, hit with some popcorn. The situation with regards to Reeves, it's just absolutely mind-boggling to me. I don't know what the jurors, 6 jurors, first of all, I don't understand why that was the situation.
It's Florida,
But
that's
then
the
other
rules.
thing-
That's the rules. I think it was 6 for Drejka also, in his case.
Right, but what I'm saying is I never understood that with regards to a criminal case like that. There shouldn't be 6, there should be 12. There really needs to be 12 people sitting there deliberating. And that's what we have in Jersey.
But what you just told me is that Drejka took a tumble, was actually shoved, but he was found guilty. And the guy who we think got hit, maybe the jury thinks he got hit by a cell phone, maybe got hit by some popcorn by a guy who's in another aisle of a movie theater, he's free.
Well, look, the bottom line is if I was Drejka's attorney, I would do a change of venue to Kenosha, all right? And then he'd probably get off there. But the situation with
these two trials are in the same judicial district in Florida.
I understand
Al. There's
that.
no
But what I'm trying to
difference
tell
in
you-
the jury pool.
But this is the most bizarre case I have ever seen in my life. This doesn't make any sense whatsoever. The pushing of this guy, I don't think it was warranted to shoot him. I don't think at any point that
Right, and the jury agreed. He's doing 20 years. He's doing 20 years.
But the popcorn thing is even more bizarre to me. How they could have said that was self-defense.
Okay.
I mean, I made that joke about, assault and battery. But, I mean, that's exactly what this was, assault and battery. And yet this man is getting off. And you said about the fact he was walking his daughter down the aisle and everything else. But he had been home the entire time, which is even more tragic.
Wouldn't have been allowed to go to the wedding without the not guilty verdict. Bernardo Villalona, can you make any sense for the folks at home? Because this is part of the outrage. People don't understand how these juries come to these verdicts. But these two cases are basically in the same judicial district down in Florida, different counties, Pasco and Pinellas, right next to each other.
So while there are some similarities, there are also some huge differences. Aside from completely different jurors that sat and listened to each case, you got to think when it came to Michael Drejka, there was a point of reflection. There were a couple of seconds where Michael Drejka had the time to actually reflect and see what was going on. Aside from that, remember with the Drejka trial that prior bad act came in where he had done the same thing at a prior occasion, having to deal with a handicap parking space. But also with Michael Drejka, his statement came in, and his videotape statement, he came off as being very macho, very cocky, very starting. You know, he wasn't a likable person. Like at no time did he show any kind of remorse. It was almost like he was proud of having shot this man. Also, aside from that, he did not testify at the trial. So there was no testimony. The jury did not hear from Michael Drejka. When we look at Curtis Reeves, we're looking at a much older man, a man that's 70-something years old, and also was a cop who served his county, who served those same people that are on that jury pool. And aside from that, he came off as a much more sympathetic guy when he testified. Like people actually could see their grandfather or an older person when they were listening and looking at Curtis Reeves testifying. So those are the huge differences. One testified, one didn't. Different defense attorneys. Curtis Reeves' defense attorneys were much, much stronger in the sense that they were very strong at going at the prosecution and breaking apart their case. So I don't think necessarily that the jury had any doubt in the sense of, oh my God, he definitely did not do it. He definitely did not intend to kill him. I think that they probably think maybe he did, but the prosecution didn't prove that beyond a reasonable doubt.